Hello and Assalamu alaikum. Welcome to another episode of Law Hive powered by ZABFMDigital, your go-to space to learn about law, legal reforms, and policy in Pakistan and beyond. I'm your host, 𝗛𝗵MDigital, and today we're going to dive into a very critical topic of alternative dispute resolution, particularly arbitration in Pakistan. To discuss all this and more, we have with us Syed Mustafa Mahdi, an alumni from ZABFMDigital, a High Court advocate, as well as an expert in arbitration. His professional accreditations stem from Chartered Institute of Arbitrators from the United Kingdom, Malaysia Institute of Arbitrators, and Arbitrators and Mediators Institute of the New Zealand. He's also the only person nominated by the European Union to become chairperson for arbitrators in Pakistan. Welcome aboard, Mustafa.
Thank you, Zena, for having me, and it's lovely to be back at my university.
Thank you so much for taking your time out, Mustafa. Now, before we dive into all the questions, let's give the audience a little bit of background into arbitration. Now, initially, our original act stems from colonial era, pre-partition Arbitration Act of 1940. The more modern act is from 2011, Recognition and Enforcement, Arbitration Agreements, and Foreign Arbitral Awards Act. Finally, that also puts Pakistan in line with the New York Convention of 1958. Now, very recently, a draft proposal arbitration bill is on the forefront, is currently in the parliament right now of 2024. Keeping all of this in mind, do you feel that judicial approach towards ADR, in particular arbitration, has shifted over time?
Okay, so my understanding of this 85-year-old Arbitration Act is that we've had numerous amounts of talks, discussions, judicial jurisprudence developing over the last 85 years. But I think it was high time that we needed something that was more effective, more straightforward, I'd say, and allows the arbitration regime to evolve as opposed to being pushed, which is currently the state of Pakistan. So I think after 85 years, I think it was high time that Pakistan needed something in terms of a law that was in field and something that is already in line with the international best practices. So we've had certain, I'd say, disappointments in terms of how arbitration has been perceived globally and how Pakistan has been treated as a seat of arbitration. But I think things did a bit better when back in 2005 Pakistan became a signatory to the New York Convention. Then it took again 6 years for something to formulate in the shape of an act, and foreign awards were being enforced in Pakistan in line with the international best practices, including the New York Convention. But I think in terms of the domestic proceedings, we were still lagging behind as opposed to our neighboring countries or even the West. And that has been predominantly one of the reasons why the law did not allow either the proceedings or either the judiciary to actually explore something that has been prevailing globally in the arbitration regime. So I think with the introduction of this act, there's been a lot of hype in the market. People are practitioners, I'd say, are very excited with the fact that we will be adopting the model law, the UNCITRAL model law, and there will be room for an improvement in terms of jurisprudence, in terms of confidence, and in terms of the actual essence of this word that is arbitration. So I think we are all looking forward for the promulgation, and once this is promulgated, we will definitely see a different shift in terms of how proceedings, how the court, or how the general market in terms of investors do look Pakistan as a jurisdiction for arbitration.
Can you give a bit of a legal background and a scrutiny of how this new bill would come into practice and how well it aligns with the UNCITRAL model law of international commercial arbitration?
I think in terms of the UNCITRAL model law, we've seen a lot of countries adapting. I think goes back to 1966 when the UNGA generally approved the formation of UNCITRAL model law. There were, as of now, I think we have already 60 member states globally
Right.
who've actually adopted the UNCITRAL model law, and specifically considering the fact that Pakistan has a certain colonial system of enforcement and in-field laws. So I think something that revamps and changes the way how a certain area of law is being perceived, not just domestically but globally as well. So I think we do understand that there were a lot of loopholes in the previous Arbitration Act, which needed a complete overhaul. And when we say overhaul, even more so, we've seen the judges weren't inclined to actually, push their discretion to a certain limit, because obviously the law did not allow them to do so. So by introduction of this act, which again is an Arbitration Act of 2024, and as we speak, it's 2025.
Right.
So I think we are still, a year
Into this
now.
discussion.
And this discussion, to
It's
be
still in
honest,
the parliament.
and it's still in the parliament, still not there.
Hmm.
So I think this is something that needs to probably gear up, and by the time it comes into field, we also need to see, the implications of how this is being perceived in the market, by the courts, by the practitioners. I'd not say there are no loopholes in any law. Obviously, when we act as counsels or as members of the tribunal, we are actually looking forward to some guidance through a certain set of rules. But given the fact that the previous act has been redundant, I'd say.
Mhm.
So with this new act coming into force, I think the overall parties that are involved in any proceeding are actually looking forward to something that gives them the power and the room to actually develop this law positively, and we achieve what the law is meant for.
So you mentioned earlier that the world has perceived Pakistan not so much in a bright light because of the arbitration seat, that Pakistan is not exactly a preferred choice. That goes equally for the domestic as well as the international investors. Do you think with the enactment of this act, maybe we'll see Pakistan becoming an arbitration seat of sometime in the future of choice?
I definitely think that like other jurisdictions where the model law is already enacted, we've seen a certain pace developed into an arbitration. We've seen the courts building that confidence. We've seen that the result of courts having that confidence through those rules has promulgated an ease of business as well. So I mean, all these factors accumulate to the fact that there is a certain sort of confidence that a certain jurisdiction gives. Now, in terms of Pakistan, we've seen like absolutely ups and downs. So if I speak of
Instability
instability, yeah,
would
to be
be the right
very
word.
specific, yeah. So if I'd say over the last 5-10 years, the arbitration regime has been in sort of positive direction. We've seen a lot of pro enforcement. We've actually seen, I'd say, less judicial court intervention,
Right.
and we've seen that courts are
And judiciary
not,
promoting ADR
and judiciary
on
promoting ADR
various
as well. Yes,
forums.
and I think that's also because we've done a couple of seminars. We've done a couple of foreign speakers coming to Pakistan on arbitration, and they actually see the act that we already have, and they even have been pushing the fact that there's something that is probably more of an exercised role, but not something that could evolve the situation of Pakistan to build a certain sort of confidence. So by Pakistan adopting the model law, I think what we're actually doing is we're coming into that level playing field,
Right.
where jurisdictions do agree, accept, and they understand that once a matter or if a dispute comes up on the surface of any agreement, so it would not take a number of years for it to be decided or for it to be overturned. And I mean, we've got numerous examples where after the adjudication of, let's say, 5 years, 10 years, the court comes to a conclusion, or even the apex court comes to a
Right.
conclusion where they technically declare that the agreement is null and void. and then automatically the whole set of proceeding goes to an international tribunal, probably
Right.
before the PCA or proceedings. So that is particularly the reason why we needed something that is more effective and more relatable for foreign investors, so that they have that sort of confidence. As
Some
far as,
recourse in Pakistan,
yes, definitely.
some legal recourse.
And certainly, in terms of seat, I think once we do adapt, there's no, I have no, I'd say, I don't feel that Pakistan would not be able to, actually put itself or push itself as a seat for arbitration. So there can be situations where we probably may have highs or lows, but even otherwise, in terms of Pakistan positioning itself according to the model law, I don't feel that the general essence in the market is that we will not be able to cope up with the model law.
That sounds all wonderful. And, again, like you said, it's going in the right direction. So I would like to bring your attention to one of the sections that I came across that talks about extent of judicial intervention. According to the new act, Section 6, it talks about how there would be no court or judicial authority shall intervene except where so provided in this act. So, in other words, judicial intervention is down to a minimal. However, you see a contrasting section again, Bill. I realize that the doors to judicial intervention always remain open, even in this act. So, Section 10 specifically talks about interim measures that you can seek before the competent court, either during or even after. So, what do you think of this one?
I think judicial intervention has been a topic where the current act also, has in a number of judgments entailed that the courts will not settle the court of appeal. They will not reopen evidence. They will not look into, the mere or typical technicalities which probably could be avoided. But I think by specifying so in this new bill, I think what we're actually doing is that we're ensuring that, if a party has agreed to a certain sort of a dispute resolution, and they would want a certain sort of an ad hoc situation where either a certain institution or an ad hoc procedure is being adapted for the parties to resolve their dispute. So therefore, the judiciary should not just be there at the forefront, doing more so of a micromanagement. But like again, you said, I think in terms of a conflicting section that you just stated, I think that again gives judiciary the room. But I think by relying or stating something, it's best for them as well, for the bar as well, to ensure that if there's a certain sort of discretion or there's a certain sort of closed door policy, I'd say, they have to exercise, they should do so. Because obviously, if a tribunal is empowered to do a certain sort of a quasi judicial proceeding,
Right.
they should be allowed to do so. And that's what the parties have agreed as well. So, but even otherwise, but if there's a certain sort of a plea where, there's a certain sort of a misconduct, the arbitral proceedings have a certain level of bias, parties are not given the right of hearing, I think, then it's
You
much
do have
practical to
to
say that
knock the
there
doors
has
of
to be there
court
has to be a certain sort of
intervention.
intervention.
Right.
So, but I think, a cautious sort of an intervention or a discretionary exercise would reap good results for this new bill and the years we have to see in the next couple of years.
Also, I believe the practice overall for the litigators has been constantly to knock the doors of, court intervention is the primary aspect. So maybe with the passage of time, that exercise will be eliminated or down to a minimal. And I think this is exactly what the Act is aiming for. So it's leaving some door open for court intervention, but at the same time, with Section 6, it's categorically limiting it. This is fairly a new aspect in this Act. I want to talk about the interim measures. Since we talked about interim measures by the competent court, what exactly are interim measures? How do you see this new act being different from 2011 one?
Okay, so I think judicial intervention is not something that should come across as a certain sort of a dark cliche in terms of an arbitration proceeding. I think if there's an apparent bias, if there's a legal misconduct, there should be judicial intervention. I mean, I personally see myself positioned as, in a number of arbitral proceedings as a member of the tribunal. And we know for a fact that there are certain times where there's a certain sort of discrepancy amongst the tribunal. There's a certain sort of delay tactic being deployed by either the parties or either the councils as well. So I think there's no harm in getting certain sort of clarification in terms of interim measures. So it could be either in terms of having a question being decided by a court of competent jurisdiction. There would be an interim measure. It could be either in terms of if the tribunal is of the view that there should be certain orders as to attachments or any interim orders in field that should be necessary to conduct the next course of proceedings. Obviously, you will have to seek assistance from the court as well. So there's no harm in having a judicial intervention where it so is required. But I think one thing that probably we expect something coming from the bar is that whenever such interim measures are being placed before any court, they need to have or make certain sort of bold decisions, certain sort of decisions which are timely in manner, so that the essence of the act and the arbitration proceedings does not halt and they do not completely turn out to be a regular court proceedings. We've seen worse examples where literally there's a list pendants in currently in the courts as well in Sindh, where it's taken literally 20 years to have a tribunal appointed.
Wow, just the appointment of a tribunal.
Just the appointment,
wow.
Because it keeps it keeps getting challenged by the parties.
Right.
So either the parties reluctant.
So that
to
must
go
be a
into
delaying
arbitration.
tactic more so.
It could be a delay tactic as well. It could also be termed as something that is a right of a party, where they feel that something is a dispute which probably is there before the court should not be tried under the arbitration, should go before a court. So I think, but again, when it comes to having certain things resolved, I think the bar needs to have a more proactive approach in order to ensure that the law is being applied in the letter and spirit.
So, any personal experiences of yours where you have seen, as you just mentioned, the appointment of a tribunal has taken that long? With this act in place, do you believe the expedited timeline that they have mentioned, it's actually going to be in practice as well and not just in theory?
I think I've seen a number of arbitrations. Generally, the first schedule of the current act allows an arbitration proceeding to conclude in a period of 4 months. Then
was it ever concluded in 4 months
I'll
practice?
I'll be honest. I've seen a couple of examples where it has, and it also depends on the sort or the nature of dispute that's coming across a tribunal. So, just like a normal litigation case, we're not talking about like 2-3 files. If we're talking about a certain construction dispute, we're talking about like bundles of volume.
Right.
So we're like literally looking at 20-30 sets of document that need to be examined, that need to be that need to go through a process of evidence. So 4 months probably is too short a time.
Right.
But I think with the new act, it's probably given a time frame of 18 months.
Yes.
Practically speaking, I don't think so that 18 months would not be a good time.
Sufficient time.
It should be a sufficient time, and even otherwise, I think there's also a proviso in the current bill where if the court feels, again, we come back to the court intervention part again.
Yeah.
So
Inevitably.
in the view of a court, if they feel that the tribunal has probably not utilized the time as it was being agreed under the law, so they may have or they may pass an order where there is a certain reduction in the fee of the arbitrator as well. There could be a removal of the arbitrator as well. But that is again, a discretion. So I think, the bar needs to exercise a discretion in a manner which is positively concluding a certain dispute. And then obviously, there's a regular course of execution, enforcement, appeals, objections in field. So that can take place simultaneously. But as far as this set of proceeding that is concerned, for which this bill or this act is there in field, that should be applied in letter and spirit.
So I have to compare this new act because it does adopt the UNCITRAL model law. If you had to compare this with Singapore and Hong Kong and even London for that matter, how much judicial intervention do you see for the arbitral tribunal in the first place? Because it sounds a lot like we've hired a third party to resolve a dispute, and then for that third party we go to another fourth party which is called the court intervention. How much of a court intervention, let's call it the fourth party, right? How much of that fourth party intervention do you see in other jurisdictions?
So I'll tell you an example. This is like 6 years ago, probably 5, 6 years ago, when it was a hype. It was a peak time of COVID. I was engaged by one of the Singaporean councils to act as a co-counsel in an arbitration and certain proceedings back in High Court as well. So we just had a discussion, and they were actually asking us, as to how proceedings take place in Pakistan. So it was sad to say, I'd say, that I told them that we particularly have to, take an arbitration agreement,
Right.
go before a court,
Yes.
tell the court that this is an application
A point.
which would await certain objections, which would await certain services to be served. The court would then come to a conclusion after a minimal period, let's say 2, 3, 4 years, and then they would actually agree or refer the matter to arbitration. As opposed to those jurisdictions where a certain contract has a typical clause
explicitly mentioned,
in case of a dispute, you just have to send a certain sort of notice for 14 days or 20 days or let's say a month, and if either of the party does not confer with a certain appointment or does not refer the matter to arbitration, then obviously you may have to probably go to the court, or if there's a proviso of a sole arbitrator or an arbitral institution,
Right.
the matter automatically gets into that machine,
Right.
into that process. So if we have the same adaptability of things without court intervention, so that will probably ease the whole process and the essence of why this arbitration needs to take place effectively.
And actually become an alternative dispute resolution.
I think personally I would disagree with this word as of now in 2025.
Because currently it doesn't,
it's an alternate. I mean, if two parties are literally signing an agreement and they say that we would not want to go to a court, we would want to go into an arbitration. It's not an alternate.
Exactly.
Like legally speaking, it's not an alternate. It's a forum that you've decided, and you automatically go to that forum.
But that's the thing. When you explicitly decide in an agreement that we will go into arbitration, so you've decided this. But in Pakistan, there's still a lot of court intervention.
Yes, that is true.
So the idea of alternative dispute resolution was avoidance of court, no?
Avoidance of court, avoidance of even cost, avoidance of time
and litigation,
avoidance of having a matter being resolved. So I think all these factors were there in field to ensure that forms of alternate dispute resolution, either it's mediation, adjudication, or arbitration, conciliation for that matter. Yes. So those need to be in field so that we just do not right away enter into a court and have the matter pending. I mean, it's sad to say, but a typical life cycle of a civil proceeding in Pakistan is around 20 years.
Yeah.
We've got a certain tendency across all courts of 2.2 million cases, and we've seen the cases rising every year.
Also, the idea of ADR was to ensure privacy of claims, no?
That is true.
So when they end up coming to the court, either for enforcement or interim measures, and anything for that matter, everything does become public.
It does become up. It's automatically public document. So yes, everyone has access to it. But I think specifically speaking about the proceeding itself, so as far as the proceedings are concerned, there's a definite level of confidentiality that's there in field, and so
as long as it's in arbitration.
As long as
the moment it comes before any court of law,
it automatically changes its nature. Yeah.
So that kind of defeats the purpose again of ADR.
I'd say not defeat, but I'd say rather if it's something has been decided and it's coming for enforcement, and it's only coming for enforcement.
But it's not just coming for enforcement. That's the problem.
For a challenge as well.
Yeah. So it could be for a number of reasons during or even at the start. But enforcement is very much at the end, and as you mentioned, it takes quite a long time, even for the appointment of a tribunal.
True that. True. I agree with that part. It's
quite unfortunate, but from your personal experience, and I'm sure the audience would really like to know, any law student or some early lawyer who's interested in expanding into the area of arbitration, how have you been facing this old boys club arbitrators? How do you see that? How challenging has it been for you to maybe, infiltrate that group of arbitrators?
So I think number one, the problem in Pakistan is that I personally feel as of now that we only have a handful amount of firms that do practice into arbitration. Number one, it's a certain sort of niche. So when we do not have certain opportunities within the market, it's actually difficult for the new entrants. I mean, just like myself as well. A couple of years ago, it was difficult for me to get into or get this sort of work for arbitration. But I think it again couples down to the fact that uh, you need to have a certain level of understanding, both academically as well as practical exposure. So I think if you start, I mean, my journey has been that it was from an academic transformation into an arbitration
Mm-hmm.
towards getting the practical side of arbitration. So I started my career as an adjudicator
Mm-hmm.
for one of the English firms, and then subsequently I came into arbitration. Then thereafter, I think takes certain level. So it's not a matter that it's a certain sort of a gold area of law which no one can practice. So
Mm-hmm.
you look at any construction document, you look at any builder's document, you'd see a certain sort of form of arbitration clause over there.
Right.
So now the only essence is that if you want the parties to exercise or the court to actually exercise that certain clause,
Mm-hmm.
and then build around your practice. But like you referred earlier, the old boys club.
Mm-hmm.
I don't know. Probably I'd be facing the same question in the next 10, 15 years when I'll be part of that old boys club.
So that means you have entered.
I'd say not as of now, but
Uh-huh.
yes, the current proceeding that I actually engage in that I already have at the moment. So I have people who come from a distinct engineering background.
Mm-hmm.
We share a tribunal with a couple of retired judges as well.
Right.
And not that it's not a sort of a learning, but I think it's their inclination and understanding is again from the same mindset that it's more so like a judicial proceeding. So they do
Exactly.
not consider the fact that there's a reason why parties have opted for an arbitration. There's an essence attached to this word which needs to be enforced in letter and spirit. We can have a certain procedural order for the whole proceeding till the end, and it can be complied generally with a certain sort of exceptions. But we just cannot take them as a sort of a normal judicial proceeding, which would take a number of years for
Right.
parties. Because then you detach yourself from that essence of arbitration.
Mm.
So automatically, once it converts into a regular proceeding, parties, councils, tribunal, they all lose hope automatically. So I think personally with me, I try and ensure that proceedings are conducted timely. We have explicit written orders.
Right.
I'm They definitely get challenged in the court, but if there's substance in what you're writing in terms of any interim order or a certain procedure or a certain order,
Mm-hmm.
I think the courts are more so inclined to actually read between the lines
Mm-hmm.
and not just a mere order which is just prone to an open challenge before any court.
Right.
So the idea, my personal idea, opinion in this matter is that there should be a certain sort of substance across whatever you write during the proceeding, so that if it gets challenged before any forum, which is actually definitely the right of a party,
Mm.
it's actually something for the court to consider, or just be blank about something, and it's out there again litigating in a normal fashion.
Right. So you mentioned you would be a part of the old boys club 10 to 15 years down the lane. Wishing you all the best over there. But do you believe that there's a lot of scope for the young lawyers then? I mean, if once this act is enacted, do you believe there is going to be scope? Should we encourage our law students, early young lawyers who are entering the market? Should we encourage them to become arbitrators?
I think we should definitely encourage them. You just have a look at the West. There's a mandatory mediation process for all civil proceedings back in England and Wales. Arbitrations agreements are applied, enforced in letter and spirit. So why not Pakistan? I mean, if you're following a model law,
Right.
then obviously we're creating opportunities, right? It's not like a certain threat.
Mm-hmm.
I think there's also a certain mindset that the young lawyers need to change,
Mm-hmm.
and that mindset needs to understand that uh, practicing law is not only about being there before a court every day 8:30 in the
Right.
morning.
It's not just litigation.
It's not just dedication. There's a whole scope. There are multiple areas of law which you can probably practice, but it definitely requires a certain amount of time, energy, and you just
And
have to believe.
interest.
And interest, yes.
Interest,
And you've got
definitely.
to believe in the fact that because obviously if there's an interim measure, if there's a court intervention, there is a learning in the court as well. So we get orders from the court, we get directions from the court, we instruct parties as well. So it's not just that if someone's practicing into arbitration, they're like completely off from
Exclusively on arbitration.
they're
Right.
completely off from litigation.
Right.
So it gives the opportunity, but something that is much more effective, and something probably the developed nations are actually adapting. So if we let's say we consider Middle East, so there's a huge amount of arbitration work back in the Middle East, and since there's a lot of construction out there, so there's a lot of arbitration automatically over there
So
as
would you
well.
say specializing in arbitration has opened up more opportunities for you than litigation has?
I'd say it's a mix for me.
Mm-hmm.
To be honest, I was not referred, or I do not belong to any of the associated old boys club.
Mm-hmm.
So it was all new for me. But yes, it did open a lot of opportunities. I mean, you've got speaking slots, you've got trainings, you've got judicial trainings, you can do a lot of trainings back at school amongst your associates. I've probably trained a number of arbitration associates back at work as well. And I literally pushed them to pursue this area of law because obviously, if we are adopting something that is in line with the international practices, we know for a fact that in the next couple of years we are having a certain docket of arbitration that will be shared amongst the industry.
And you have been making waves given that European Union has already recognized your skills
Yes.
and your hard work. So, I mean, you are the testament that every young student or law student should aspire to look at and become. Thank you so much for this informative session, Mustafa. I would like to ask you if there's any advice that you would like to share with our audience regarding this particular field.
Okay, so I think with the new act that's already in process of being enacted, I think when my advice would be that if let's say if I'm acting as a member of a tribunal, I should ensure that the provisos of the new act are being applied correctly.
Right.
They're not being misused. Same goes for the parties that probably are appearing before us. And I'd also, humbly request even the bar to actually ensure that things are being exercised in a certain manner as they've been written. So rather than having or using discretion as a very broad term, I think it's more practical for even for the bar because they'll be setting a certain threshold for the industry. So I think it's uh, for me personally, it's the bar who needs to ensure that that discretion is exercised effectively, so that we have the results that we need in in the next coming years for arbitration, and we just don't have an assumption that probably this act would definitely be a good fit in the next 10 years. Let's just aim for the next 4 5 years for it to be a successful thing, and then we can see that how a certain sort of a judicial backlog is being dropped, and even more so the foreign jurisdiction that have been eyeing on Pakistan, they have a certain level of confidence that with the enactment of new laws, particularly the Arbitration Act, Pakistan is a good fit and a good suited jurisdiction for any dispute to be resolved.
Thank you so much, Mustafa, for that valuable insight for all our audience to see. Join us for another episode next week. Until then, take care.